of you are not able to join the proceedings because the room is full, the Zoom attendance limit is reached, don't worry. You can watch it on YouTube, on Tax Sutra's YouTube page. We are streaming this webinar live, as you can see it on the top corner of your screen. The webinar is streaming live on YouTube. We'll just wait for 20 more seconds and begin this. We do not want anyone to miss even a single second of this special webinar. TOLA, reassessment, Ashish Agarwal. If either of the three were not good enough, to have a cocktail of the three controversial issues in one single case and forceful arguments being made by the taxpayers, they had won at the High Court level, and then we came to the Supreme Court. Wow, you cannot serve a better topic, a better appetizer, dessert, main course for TaxTonic 75. This is really a special TaxTonic, a high-profile one, where high courts, a case where the high courts were against the revenue, most of them. Taxpayers were confident going into the Supreme Court hearings. Well, that was until Additional Solicitor General of India, ASG, N. Venkataraman, stepped in at the Supreme Court. By the time Venkat sir finished his arguments, the case was on a knife's edge. When Chief Justice of India, Dr. D.Y. Chandrachud, pronounced the judgment in favor of revenue just about a week ago, it was clear that Venkat sir's arguments, especially the one on amendment by substitution, had carried the day. Ashish Agarwal, Bharti Hexacom, MFN, and now TOLA. Just when everyone thinks that the game is over, Venkat sir has this knack of pulling off a rabbit out of his hat. For revenue, he is no less than MS Dhoni, the ultimate closer. For taxpayers, the only hope now is the law of averages catches up with even the greats. Today, though, is a special occasion. As TaxTonic, our subscriber-only thought leadership series, which was unveiled 2 years ago, hits the 75th episode mark. So we can't thank you enough for gracing this special occasion. We are also grateful to our readers for the love and loyalty that you have bestowed on this series. A special thanks to our TaxTonic contributor, Sachin Sastakar, who has so wonderfully moderated these sessions. Back-breaking research goes into producing these TaxTonics, and no words of praise will be too high for Sachin. Incidentally, he tells me he spent 50 hours reading this judgment and doing research on this particular case. The next 120 minutes, though, are all about the TOLA batch of reassessment cases, and it is my pleasure to invite ASG Venkat sir to be delivering his address. Before that, I request Sachin to give a small opening statement. 75th special TaxTonic. Congratulations, Sachin, to you. Before we go to Venkat sir, I just want you to open the TaxTonic for us.
Sure. Thanks, Arun, and I think thank you, Venkat sir, for gracing this occasion, and we really are thrilled and overwhelmed, with the support from our Tax Sutra subscriber, and what a way to celebrate 75th TaxTonic with you, discussing a landmark judgment at a landmark in a landmark episode. But I think unlike all other TaxTonic where we straight away with the Q&A and the deliberation, I think maybe for the 75th we are going to have a little aberration. I'm going to be a silent listener for 75 minutes, and possibly then I'm going to start with my opening questions. But I think till that I would like to listen to you. Fortunately, I had a good opportunity to share with you some of the thought-provoking questions to you. I believe you will be answering few of them during the course of your deliberations itself. And possibly that is why I would also request all the Tax Sutra subscribers who are attending today's session, please hold your guns for some time, because sir will be deliberating, at length about this judgment. How to read this judgment is also an art or a science or a commerce, I don't know. But I took good amount of time, good amount of iteration to understand the judgment and then formulate some question. But I think hold your guns for some time. Over to you, Arun. So I don't come in between sir and the entire Tax Sutra subscriber platform. for understanding his views, and then I will start with my questions.
Yeah, we have, we'll have 75 to 90 minutes of Sir's address, followed by Sachin's questions. If you have your comments or feedback, any questions for Venkat sir, please type them in the Q&A box, not the chat box. We'll try to take a few of them. If we were to take all of them, I think Venkat sir will miss tomorrow's Supreme Court hearing. So we won't do that. On that note, a special thanks once again to Venkat sir. A lot of dignitaries are joining this webinar. And I'm sure that everyone is going to have their ears firmly grounded to Venkat sir's talk. On that note, over to you, Venkat sir. The floor is all yours.
Sharada Sharadam Bhoja Vadana Vadanam Pujai Sarvata Sarvata Smakam Sannithim Kriya. Arun, Sachin, Anjur, Tax Sutra subscribers, officers of the revenue, interns of the Supreme Court, and juniors across tax offices in India. Namaste. It has always been a pleasure to talk through Tax Sutra and through Arun. And this time it's a special privilege. For the reason I had defaulted twice and he still tolerated me. And we have refixed it today. And I'm so happy that 1,000 people have already logged into this webinar in the Zoom link. And therefore, Arun has also generated simultaneously a YouTube link in case people who have not logged in here may attempt to join there. The way we read this judgment is something unique. The style is very unique. And therefore, even before we get into what this judgment has actually delivered, we need to understand a few things and a few experiences which we need to narrate for especially young minds, young children of the bar and the young chartered account professionals. This is one of the fierce battle after MFN fought in the Supreme Court. And amazing preparation by the assessee councils. Hats off to them. Kind of level of preparation each one, and each one took across India council scale, both seniors and others across India, and they made the pains of reaching the Supreme Court physically and doing the matter, one after the other in a sequence. Each one of them added their own unique dimensions and value to this case. There was no repetition of arguments by one repeating the same by the other. Each one had a style. Each one had something to contribute. So thanks a lot to those councils. It was sitting on the other side. It was such a big learning experience for me. One. Two, more importantly, this is one judgment which will remain as a unique piece in the galaxy of tax judgments delivered by the Supreme Court for the simple reason. This is one of the rarest judgments where it has not been rendered just by discussing the two arguments of both sides and delivering it. Assessees argued X, Y, Z, revenue argued ABC, discussion, and then finding no. This is not a judgment of that genre. It's a judgment which has added so much value on its own. We should give the credit to the court. We should give the credit to the author, the Honorable Chief Justice. There's so much originality, creativity, and thrust written with a lot of passion. So we will discuss those areas also as part of the scheme in today's talk. Lot of value addition by the court in delivering some important concrete concepts on tax law. Three, the pattern in which this judgment has been delivered is also unique. If those who are familiar reading the 2 volumes of Nani Ji's Income Tax Act, if you are used to reading that or referring that, this judgment will look like an appendix to volume 2 of Naniji's style. Every sentence is nothing but conveying a ratio of some decisions already rendered by some court on that point. It's a collection of ratios which has formed the basis of this judgment. The genesis of this judgment is a collection of ratios. So a lot of work, hard work has happened also at the court's end. So with this background, let us venture to understand what TOLA judgment finally has declared. The first 44 paragraphs of the judgment has laid the foundation as to what is in store for the rest. These foundational 44 paragraphs are extremely important, more so for young tax professionals, chartered accountants and lawyers, people who are as old as we are. We have all learned something our way 30, 40 years, and we will try to manage it our way for the rest. But certain very nuanced principles of law have been beautifully described and portrayed in this judgment in the first 44 paragraphs. And what are they? For example, the judgment now seeks to say, what does an assessment actually mean? A very precise, neat question, and answers it in just one sentence. The responsibility of an AO carrying out an assessment is for what? Interest of public revenue and prevention of evasion or escapement of tax liability, which are legitimate. So this is the contour which would an AO focus at the time of passing an assessment order. 2. What would constitute a reassessment? The court has laid down 4 important principles as to, in a nutshell, based on all earlier rulings. 1. A reassessment is nothing but a fresh assessment. 2. It is an assessment which substitutes the earlier assessment. 3. It's an assessment because it substitutes an earlier assessment. It extinguishes vested rights and therefore needs to follow quasi-judicial process. 4. Generally, reassessments are bound by 2 impactful statutory influences, which are timelines and sanction. So, for a young lawyer or a young chartered accountant, if you read this judgment, you will have a fair idea of how to examine a reassessment when a matter comes to you, a show cause comes to you, or a client comes to you for an advice. The judgment is an aid. It lays down these 4 principles. The third takeaway in the first 44 paragraphs is, what are the jurisdictional issues which can be raised in a reassessment? And catalogs 3 of them. Timelines, whether it is 4 or 6 or 3 or 10, now 3 or 5. 2, the authority, the process and the manner of seeking and obtaining the sanction. These are jurisdictional issues. And 3, had there been any waiver or overlooking of a statutory requirement during the process of reassessment? The bench of 3 judges have concluded any infraction or a breach on these 3 would constitute jurisdictional issues in reassessment. This is more important for revenue officers who are listening to this talk, that you need to be careful on these 3 issues. most of your old 148 notices and your current 148 preceding that 148D order are prone to challenge only because of these three faults. And the way the process of sanction, see, most of your petitions before the Supreme Court is an officer has signed a sanction of more than 20 orders, 50 orders on one day. If you're able to show that this sanction preceded discussions, minutes, on different dates for different cases, and the approving authority has the knowledge of this matter earlier, then signing 50 orders on one day is not a breach. But if you're not able to show that proof to the court, then the court will jump to the conclusion, how can a senior officer of that rank sign 50 approvals on some dates? Complete non-application of mine. Sanction is a jurisdictional issue. And whenever I talk to these officers, they're able to send me minutes to say that so much of discussion had happened, but your counters don't say so. And your sanctioning processes, notes, you have to say that even though it was signed, it preceded these, write 3 sentences. Nothing wrong about it. After all, you have done it. But it doesn't get reflected anywhere. Therefore, sanction is becoming a huge issue. So is the case when it comes to timelines, when you're invoking the extended period. Ensure that the proper basic material available gets reflected. If it is not available, be sure, this is something, a request or a caution conveyed to the revenue officers through this talk. Don't attempt to issue notices just for the sake of it. They all get quashed. The times have changed in the courts. Courts are more liberal, more assessee friendly, and don't think that whatever you do will get protected. You won't get protected unless you have the legal basis to stand. Judges are now more prone to decide matters in favor of the assessee if they find the mildest infractions. So these 3 aspects are very critical, and the court has said that they are jurisdictional issues. Now we go to the second segment in this 44 paragraphs. A beautiful narration has been rendered by the court from paragraph 33 to paragraph 44. 11 paragraphs on tools of interpretation. What are the tools you need to resort to when you handle complex, conflicting statutory problems, either as a quasi-judicial authority or by a court? 11 paragraphs, so beautifully mapped. Therefore, 3 or 4 tools have been discussed in this judgment. The court has brought out so nicely and very effectively the distinction between a literal interpretation and a strict interpretation. This bottom line is very important. It says a strict interpretation is a process through which you normally try to interpret the provisions of law in its normal or usual sense. Fine. But what do you mean by normal or usual sense? It needs to be defined. So the judgment says between a literal interpretation and a strict, see, these are all evolving science, evolving processes. Young lawyers, see, in our days, absurd consequences, irrelevant, you should still enforce the law. We have argued all that, left, right, and center for the assessee community. Now, these interpretations are slowly migrating into a different phase. So, young practitioners must read this judgment and try to understand how the law is slowly progressing towards tax interpretation. So, the court no longer prefers between literal interpretation and strict interpretation. The court now opts strict interpretation instead of literal interpretation. What is the difference? When it comes to strict interpretation, The difference is this: literal interpretation can lead to absurd consequences, whereas strict interpretation can avoid it. Second, a strict interpretation, through a strict interpretation, it is possible to preserve the legislative intent, which may not be possible in a literal interpretation. And three, this does not mean strict interpretation should not become synonymous slowly to loose interpretation. So the court is also trying to contain it through a contour. It says it can't lead to absurd results. It can't lead to going against the legislative intent. At the same time, strict interpretation does not mean stressed interpretation or strained interpretation. It brings out a new dimension to tax interpretation. Strict interpretation doesn't mean we need to strain ourselves and somehow try to impregnate a meaning which the law has failed to convey. And it also says strict interpretation does not mean if an unjust result is inevitable because of a legislative lapse, strict interpretation is not a filler of that lapse. Don't think moving away from literal interpretation to strict interpretation would mean you can fill legislative loopholes or gaps. That can't be done. These two bands are put in this judgment, and the flow of river of strict interpretation should manage its way between these two external contours. Now coming to harmonious interpretation. The court says it actually endorsed and applied the harmonious interpretation in this case, in these matters. When it comes to harmonious interpretation, the court has laid down certain strict concepts, some fundamental concepts when you can resort to harmonious interpretation. One, you should be able to show that you have conflicting provisions which require a harmony. That's the basic foundation. Two, by resorting to harmonious interpretation, one of the provision should not become a dead letter. Then that will define, because harmony is synchronizing it, synthesizing it, trying to align it. You can't declare one of them as dead using harmony as an interpretative tool. It also says that harmonious interpretation is something available either within the statute or even beyond the statutes. After saying this, it deals with two important concepts in TOLA. That's why these tools are employed. It says how to interpret a non-obstante clause in a tax law. Because TOLA uses the expression notwithstanding anything contained. So the court very clearly lays down the guideline when one of the provisions uses a non-obstante clause, then the presumption is, the first presumption we should make is that provision should be given an overriding effect. Because so much of arguments were canvassed, very creative, very imaginative, and very forceful arguments were made by the assessees when it came to notwithstanding. And they somehow wanted to ensure that TOLA is made ineffective post the Finance Act 2021, which they didn't succeed. So the court first laid down a principle on non-obstante. When TOLA carried a non-obstante clause, the presumption is, the legislative intent is, has to be employed and given an overriding effect. We can't disalign ourselves from this reality. So non-obstante clause must serve its objective. 2. The bandwidth of a non-obstante clause may vary from legislation to legislation, provision to provision, circumstances to circumstances. There is no uniform or universal rule that once it is non-obstante, you should only employ it this way. It can be a limited option. This court in this judgment has interpreted non-obstante in a very limited sense, which we will be coming to a little later. So it says, non-obstante, we should give overriding effect, no doubt. But to what extent it overrides has to be seen with the legislative intent. It can't be mechanical. It can't be universal. It can't be some sort of a one fit size formula. And in this case, it made it very clear, non-obstante clause in TOLA applies only for time period and only for sanction, and not for any other parts, which we will be seeing it a little later. 3. Resolution of harmony will arise employing the tool of while interpreting a non-obstante. You're able to show inconsistency between two enactments. Why this ratio was necessitated was the Supreme Court had to deal with 3 important legislations in this matter: the Income Tax Act 1961, the Finance Act 2021, and the TOLA Act 2020. All the 3 are acts of Parliament. And therefore, there was a need to harmonize. There was a need to interpret non-obstante. So, this is one, how to interpret non-obstante clause. The second principle which this judgment, see, why as a learner of law, personally, I'm better to this judgment for the simple reason, not because we have won, we are lost. It happens in every case. Sometimes we win, sometimes we lose. The way they have embedded the principles first and taking those principles and applying it to the case and resolving the dispute. Beautifully done. So, the second important, after dealing with non-obstante, the second thing which they dealt was about implied repeal. So, because this was the second major controversy which we fought in the court. When Finance Act 2021 is by way of substitution, what is that scope of substitution? What happens to laws which existed earlier? This was a major controversy because assessees conceded before the court, TOLA will certainly extend the period from 20th March to 31st March 2021. That was something which they themselves agreed. But they said nothing doing after 1/4. When Finance Act got substituted, TOLA has no life. TOLA is gone. Dead and gone was one approach, or the major approach, which the Supreme Court resolved it in this judgment, which we will see in a few minutes from now, for which the tool they used was the repugnancy test. They said, when substitution happens, unlike a case of a repeal, which goes to repeal a law, a substitution does 2 things. It repeals the law which was in existence and substitutes the law in place. So when it was argued by the assessee very strenuously to say, Finance Act got substituted, TOLA is dead, the one vacuum which they couldn't answer was, are you going to apply Finance Act for whenever notices are issued post 1/4, are you going to invoke the Finance Act 2021 or the old law which already stands repealed? The answer had to be Finance Act 2021. So when you can travel there, what is the prohibition cost in the TOLA Act, especially when 3.1 says notwithstanding specified act and permitting you further extension through notifications, why do you want to interdict there? Was the counter question posed by the court to resolve this conflict. Therefore, repugnancy test is one of the tests which they laid down, and they laid it down with very strict principles. They have laid down 3-4 important core principles on this repugnancy test. A, should be able to show inconsistency between two enactments or two provisions. 2, don't presume an implied repeal. See if it can be resolved otherwise. If it can't be resolved otherwise, then implied repeal should be the manner of last resort. And you should resort to implied repugnancy only on 3 contingencies. A, when the provisions are plainly repugnant, when you start constructing or interpreting the law on plain repugnancy, or both provisions cannot stand together, or the question of their amenability for a reasonable alignment is an impossibility. These are the 3 important exceptions the court drafted for itself to apply this law. And now, using this tool, we are now getting into the main picture from para 44 onwards. Using this tool, it now made one important distinction in its approach from that of the assessees. When the assessees pressed for an argument that TOLA and Finance Act 2021 are intertwined legislations because both are acts of parliament, and there is a reference in TOLA to Income Tax Act, which is a specified act. How did they? It's a beautiful way they webbed it. You should give it to the Assessees Council. Beautifully webbed it. How they said was this: the pyramid is the Income Tax Act 1961, which is in place. Now, one arm of it is the Finance Act 2021, substituting 147 to 151. The other arm is the TOLA, which is extending time. So when you read this into the Income Tax Act, when you read that also to Income Tax Act, there should be coterminous, was the submission. Whereas the Supreme Court resolved it the other way, using all these above tools of interpretation. One is non-obstante clause. Another is the use of the expression any. And third was the window given in 3.1 that originally it got extended through an act of parliament and subsequently it can be extended through notifications. These are the 3 tools. Three aspects available for tools of to be invoked, any one of the tools of interpretation, they apply it. So the Supreme Court made one important departure from the assessee's contention. It said, look here, the Substitution of Finance Act is a distinct process from the purpose and intent of TOLA, which is nothing but extension of time. Don't mix both. Let me explain it in 2 minutes, you'll understand it better. What do you mean by that? Supreme Court first defined the period for TOLA. This was the contention which revenue pitched, which finally the court accepted it. See, what is the period for TOLA in this whole case? Let's go to the bottom of the matter. The period is 20th March 2020 to 31st March 2021. Assessments, reassessments which can be initiated, could have been initiated for these 12 months and 10 days. Nothing beyond that. Nothing beyond that. Now, when this is the period in which you have to initiate, period in question for which you need to initiate reassessments. The Supreme Court went to the next step. There are two ways of doing it. If an officer has initiated the reassessment prior to 31/3/2021, he could have very well used the old law. Absolutely no problem. If a reassessment has to be initiated post 1/4/2021, because of the repeal of the old law and the substitution of the new law, the initiation has to be as per the new law. Now comes the third important step, which went in our favor because our arguments were accepted and their arguments were rejected. The third ratio which came out of the judgment was, look here, after all, even post 1/4/2021, you are entitled to initiate proceedings for the period 20th March to 31st March using Finance Act 2021. So when you can reach this period using Finance Act 2021, why do you want us to a judgment to scuttle? No, use Finance Act, but don't use TOLA. Why? Why? What is the legal basis for it? Is what the Supreme Court asked. When you can do this, that's also an act of parliament. And you want repugnancy to be resolved? We will resolve it because TOLA says, notwithstanding anything contained. What is notwithstanding anything contained? Notwithstanding anything contained are the specified acts. What are those specified acts? Income Tax Act 1961 is one of the specified acts. What is that Income Tax Act 1961? As substituted by Finance Act 2021. So Supreme Court in the judgment has said, when Finance Act 2021 is read as part of Income Tax Act 1961 for you for initiation of proceedings for this same period, somebody who has done it prior to 31 and somebody who does it after that. That is all the difference. When this can travel, TOLA, which says notwithstanding anything specified under the specified act. Why do you dare say, no, it has to be only the Income Tax 1961 prior to 31/3/2021 and not the Finance Act? Where do you get the legal basis? And therefore, the high courts are wrong. This is the crux of TOLA. Everything is then after that is just a multiplication of principle, which we will see. The crux of TOLA is only this. So, it said, 1, it is non-obstante. 2, it uses the expression, any notice, any sanction, any proceedings. Any can mean all, every. Can you shrink it? No. Any means only those proceedings prior to, not subsequent. And 3.1 of TOLA says, this time extension happens first through the legislation called TOLA Act 2020. And any further extension will be through notifications tabled before the Parliament. And therefore, before the expiry of 31st March and when on 31st March, when the first notification was issued, extending TOLA to 30th April, and when the second notification on 27th April was issued, extending it to 30th June, how do you say, no, Finance Act 2021 has interdicted it. It has lost all its worthiness as far as income tax is concerned. It's dead and gone. How do you say it? On what basis do you say it? What's the question? Substitution of 147 to 151 is for the procedural compliance of how to start initiate reassessment. It has nothing to do with extension of time. And TOLA has nothing to do with 147 to 151. It did not go and amend 4 years, 8 years, 6 years, 6 years, 8 years. No. It has not statutorily tinkered with the statutory time limit. It only relaxed the time limit. Judgment very clearly makes this distinction. When it only makes that little difference of relaxation and empowering it also to be done through the notification, you have to do a harmonious construction. You want to resolve the repugnancy, conflict if any, same or whatever it said in the first 44 paragraphs. It concludes by saying, prior to 31, old law. Post 14, new law. Relaxation of time limit between 20th March to 31st March. Whatever can be done either under the old law or new law, because both are only income tax law. One is not GST law. When both are income tax law, the time limit extension for this period will extend up to 30th June 2021. This is the bottom line of TOLA. While saying so, it recorded the following concessions of ours. We have conceded a few things very clearly, and it forms part of the judgment. And remember, merely the judgment doesn't factor, they conceded, therefore we are writing. No. Even though we conceded, the judgment gives reasons that our concession is also based on law. So even if we have not conceded, the court would have decided against us only, because it gives the reasons. So we conceded the following. 1. If an officer has initiated prior to 31(3), it has to be done under the old law. If an officer has initiated post 1/4/2021, then it has to be 4, has to be only 3. Let's make a public announcement, because we have considered before the court. It is very clear in the judgment. You don't have to worry. Because 4 has become 3, assessment within 4 years for 2015-16 is not covered by TOLA. 4 years, not for 6 years. 2015-16, once it becomes 3 years, because the judgment very clearly says the contours, the fixed contours of TOLA extension relaxation is only 20th March to 31st March 2021. So something which does not fall within this after the application of TOLA, read with the statutory time limit of 3 years, if it goes prior to that, there is a clear ratio in the judgment. Anything falling prior to 20th March cannot be stretched by the application of TOLA. You should fall within this radius of 20th March to 31st March, 20th March 2020 to 31st March 2021. Once you fall within the radius, then relaxation will apply. So 4 becomes 3, and therefore 15-16, for 4 becoming 3, you can't invoke TOLA. Second concession. Third, while threshold has been increased from 1 lakh to 50 lakhs, so any notice initiated after 1/4, it has to be only 50 lakhs threshold. And 4, invoking 6 years, unless you have a threshold of 50 lakhs, you can't invoke the extended period. Paragraph 48, 52, 53, and 54 clearly records our concession in this regard. So let there be complete clarity on this aspect of TOLA. Right. Now, we move to certain important principles evolved in TOLA. 1. The judgment records the fact that TOLA, the virus of TOLA, has neither been challenged nor the competence of the parliament to pass a legislation TOLA. Legislative competence is not under doubt. Virus is not challenged. Therefore, the constitutionality of it is not going to be an issue for discussion. It doesn't suffer from any unconstitutionality or illegality or a vice of that nature. Is one ratio. Two, it chose those two expressions, notwithstanding and any, which we have explained it already to you. Three, now comes this non-obstante clause, notwithstanding, it says it has only limited applicability under TOLA, because TOLA is only a relaxation provision. You can't read this beyond that. So it only, the notwithstanding is confined only to extension of time and nothing else. You can't use TOLA for anything else. Then 4, it has made it very, very clear, if time limit has expired prior to 20th March, paragraph 65, then you can't invoke TOLA. So 15, 16 is gone. 6, when assessees agree TOLA extension from 20th March 2020 to 31/3/2021, there is no legitimate reason why assessees should not accept its further extension through the notifications up to 30/6/2021. When you accept the first phase, what's your challenge in not accepting, especially when TOLA is only a mere extension? Your Finance Act cannot interdict this extension. And Finance Act nowhere interdicts this extension. Because the purpose of Finance Act is distinct from the purpose of TOLA. There is no overlap or repugnancy there. Even in reading the new 149, a beautiful interpretation has been given there by the court. Then, yes, it also said very, very clearly, see, the construction of a charging section in a tax enactment and a machinery provision in a tax enactment are the manner of construction is very, very different. When it comes to charge, it always moves in favor of the assessee. What is not within charge, you can't. Even today, somebody was arguing some matter. The chief court was saying, do you think we can create an offense under the new Indian Penal Code? We can't. Court can't create charge through a judgment. But when it comes to machinery provisions, it has the ability and has the right and the discretion to use harmonious construction to ensure that absurd outcomes are prevented. Then 2, 3 important aspects on this non-obstante clause. It says, look here, because ultimately there was vacuum. The court went on asking, what is your answer for notwithstanding, in spite of all the arguments? So not much coming from the assessee side, naturally. So the court said, look here, the purpose of a non-obstante clause is to remove obstacles. That's the whole purpose of the legislation. There's a beautiful expression, paragraph 71. The purport of a non-obstante clause is to remove obstacles. When you don't, can you now subserve and can you now sustain an interpretation which will hinder it? That is unacceptable. That's one. Then, especially when this non-obstante says override specified acts, and specified acts is defined in section 2, one of them being Income Tax Act, and Finance Act 2021 becoming part of Income Tax Act. How do you diverse this Finance Act 2021 to ensure TOLA doesn't apply? Will it qualify as specified act? It will qualify. Will you call it as Income Tax Act? It will qualify. Will you agree that it's a substitution to the Income Tax Act? You agreed. When you agree for all this, then what is a disagreement? No, TOLA, don't touch chapter 1.4. No. How? How is it possible? It's the question. Now, these are the important ratios on TOLA. 2 more things with that I will try to. I have another 10-12 minutes permitting, Sachin.
Sure, sir, sure.
Yeah, thank you. I'll definitely wait and take questions. I'll not run away. But two, three things needs to be conveyed as much as they are important. One is about sanction. Okay, because the string of judgments delivered by the Bombay High Court, Orissa High Court, all of them got reversed. And this was again one main sheet anchor point argued by the assessee quite vehemently. Two issues arise out of this in this case. See, what they were saying is this. Look here, post 1/4/2021, the sanctioning authorities are different. Which is the fact which nobody can dispute. In fact, the judgment extracts both the old 151 and the new 151 very clearly, the judgment itself. And if you see, it is so evident. The sanctioning authorities under the old regime and the sanctioning authority new regime are completely different. So their main point was anything done after 1/4/2021, you should have followed only the new sanctioning procedure. So these notices have not followed the new sanctioning procedures. And you are yourself saying sanctioning is a jurisdictional issue. Having failed in this jurisdictional aspect, you forget TOLA. Now we'll give up TOLA. Okay, you can extend. All that is fine. What is your answer for 151? 2 days of argument only on this. That's why I'm in deep admiration with all my colleagues. The first attack was on TOLA. Then they say, notwithstanding, we'll give up TOLA. Now come to 151. What is your answer for 151? Then they make a subsidiary argument. The court said, okay, tell me, okay, I'll come to this point a little later. When I deal with 142, that will be better if I come there. So for this 151, the court answered it in two parts. It said, look at the genesis of the history of this case. Because Rajiv Bansal batch is not the first round, it's the second round. Okay. So you had Ashish Agarwal, which you can't forget. It's a judgment by the Supreme Court. What does the judgment say? All these 90,000 notices are notices no doubt initiated between 1/4 and 36/2021. Nobody can doubt that. It's a fact which cannot be disputed. Two, equally considered fact, these notices were issued invoking the old law, when the old law stands substituted. And therefore, there's an implied repeat. What did the Supreme Court do in Ashish Agarwal? It said, this changeover has created bona fide doubts. When you create so much doubts in TOLA through interpretative process. So, time period, as you intertwined TOLA to say, subserve your interest, saying that no, TOLA has to be read with Finance Act and therefore TOLA is lost. Beyond. Equally bona fide, the officer could have mistaken. Extension of TOLA would also mean extension of the life of the old act till 36. Genuine. See, when it is open, this is exactly what was argued in Ashish Agarwal. To get that ratio. When you can couple TOLA and Finance Act and say this terminates that, is it unfair for an officer or so many officers to presume extension of TOLA would also mean extension of the old legislation up to 36? Because after all, they've issued the notices. We are not fighting for a notice issued post 17. No, not at all. So having issued the notices, you should not render revenue remediless. That was the genesis of Ashish Agarwal. You can't render 90,000 notices as hopeless, redundant. And could they have done it at all under 142? There was so much of debate when Ashish Agarwal came. Myself stood in 10 forums to defend why this judgment is sustainable under 142. Starting from the basic, you saw articles flew on our face. How could Supreme Court invoke 142 for a tax enactment? Historically, it has never happened. See this judgment. It quotes all the history. 142 has been issued in tax matters, even prior to Ashish. It's a straight answer for those articles. How could you have issued? And people who canvassed those, when it came to assess its interest, stand up before 9 judges in the MADA case and say, please invoke 142 and waive us penalty, waive us interest for a tax enactment. And MADA 9 judges have passed 142 order again in a tax enactment. People who said it can never be invoked, has never been invoked, stood up to argue that it can invoke and took a judgment in 142. So there is nothing called an absolute bar of 142. You are reading the Constitution. So you read 142 of the Constitution. Constitution is it's the mother document. So what are you reading now into the Constitution? Constitution under 142 sans tax law. How is it possible? It's also a law. So invocation of 142 is not a sin, as many people portrayed it during the Ashish Agarwal judgment period. This judgment answers them squarely and comprehensively. Why did it do it? A, to ensure they are not remediless. And two, it has done it on a very, very equitable basis. How? It only said the notices invoking old 148 will be construed as a show cause notice under 148 AB and start the journey under the new law, applying the new provisions, giving you the opportunity of a quasi-judicial participation. It did not say take the notice and then pass the order. Give the information, supply the information, whatever is the law that is required. So it balances both. You don't render the revenue remediless. You don't render the assessee remediless. And three, could it have done it under 142? Supreme Court relies on a judgment in this case to say 142 is always available for procedural irregularities. It is always available is the doctrine that is impregnated in this judgment. And therefore, Ashish Agarwal is right. We can't meddle with Ashish Agarwal. We can't undo it. We can't make it fruitless. What it has done is not something so patently unacceptable. So it sustained Ashish Agarwal. So once it sustained Ashish Agarwal, it said, after all, a one-time waiver has been granted because you have to start somewhere. And therefore, your 148 AB notice and the prior sanction to it under 151 under the new law could have never been obtained, and therefore it cannot be obtained, and therefore it need not be obtained. What is not possible, you can't say, then it's a non-starter. See, you reinvent the argument again in the second round of this nature. You are making what? And you are making the whole case a non-starter. Supreme Court says, how can we do this? How can we sustain this plea? When Ashish Agarwal has already said this is not possible, we are waiving that condition. So to demand a sanction under 151 under the new regime because it is issued for these notices is an impossibility. Already waived, so we can't revisit it. So you can't demand that 151 sanction there. Then they made an alternative plea. Look here, that was something which the court felt was a bit strange. Look here, for 17, 18, 18, 19, or 16, 17, 17, 18, you always had a 6-year period without TOLA. So TOLA you need not have invoked at all for issuing this 90,000 notice between this period. Imagine as an assessee and imagine as an assessee's advisor and a counsel, how many times when we issue a notice under 6 years, how many times you have filed writ petition to say, this will not come under the extended period, you ought to have done it within 4 years. And now when we issue it rightly within 4 years, you come and say to the court, no, they have 6-year period to issue the notice. Court said, how do we accept this point? Merely because you want to take TOLA out of the scheme of things. It's a very strange, skewed submission. Completely unacceptable. And therefore, this was the answer for 151. I'll take last 5 minutes. I think you are becoming restless. I'll close it. There's so much to say. No.
Please. I think you should also include your logic of surviving period, and then I think
I'm going to close it.
Please, sir.
So, therefore, it said it therefore preserved it. Now, on 142, because so many professionals are hearing this matter, a couple of things you need to know, and then we'll come for the surviving period and close it. In very clear terms, it portrays what is the surviving mechanism available to you. Very clearly. Because we'll finish this 142 and close that. These are the 2 points. See, these are the ratios this judgment has rendered on 142. All professionals should read this. It is between paragraphs 82 to 93. 142 is a power, it's a discretion vested with the widest amplitude. We can't be substituting our thought process and limitations into this discretion. Suit it to our own convenience. Use our statutory tool of interpretation, say your power are constrained. Because it says, the second important, look here, 142 is a constitutional power given to the Supreme Court judges on trust. And therefore, the bandwidth of exercise of that power should be left to the discretion of the court in deciding the scope in a particular matter. Because we are dealing with a constitutional power, not a statutory power. Okay, never mind. We are still bound by some rules. Doesn't mean that we can use it the way we want. So it defines those rules and limitations also. What are those rules and limitations under 142? 1. Whenever court invokes 142, one parameter of discretion is it consistent with the constitutional norm? You can't use 142 to render an unconstitutional objective, saying that discretion is with me. So constitutional provisions, consistent with the constitutional provision, is one limitation. Due consideration of the substantive provisions. You don't apply the statute in letter and spirit. Substantive compliance is the requirement. Why they say substantive? Because they say you can supplement the legal framework through 142. That's the last point. And 3, it very clearly says, if there is any prohibition on fundamental principles of public policy, then our 142 discretion should factor that also. And 4, 142 is entitled for supplementing existing legal framework to craft a just outcome when strict adherence to a source of law and exclusive rule-based theories create inequitable results. Para 86. And said, Ashish Agarwal has done this supplemental to craft a just and an outcome so that neither the revenue nor the assessees are rendered remediless. Now we come to the last section, which is what is the surviving period. See, They all argued before the court. Look here, your 148 notice is issued only in July 22, August 22, September 22. Your TOLA doesn't survive there. Your TOLA is only between 14 and 36. What are you talking? It's a non-starter. Quash all the notices. That was the case. So the Supreme Court, it accepted our contentions. We split the whole period into three parts. 1/4/2021 to 36. All this is captured in the judgment. 36/2021 is TOLA period. 1/7/2021 to 4/5/2022 is period prior to rendition of Ashish Agarwal. 4/5/2022 and thereafter is post Ashish Agarwal. Now look at this scenario. If you're going to say your July notices, your September 2020 notices, all this has to be scrapped. See the impact and the consequences. You can't dispute the notices, the TOLA period of April to June 2021. Nobody can dispute it. Nor can you dispute the period from May 2022, 4/5/2022 and thereafter, because it's governed by 142. It's a judgment. What does the judgment say? Please give 115 days notice. Give all the materials to 30 days. Ask them to reply within 15 days or such further extension. Then pass an order under 148 AD. And if you find it a fit case, take the approval and then go to issue the 148 notice. This is the program, calendar fixed by the court under 142. Now, can you say all this is absurd here because we have issued a notice as non-starter? Can you come to the court and say all this is useless? It won't work at all. How will the court sustain it? See, the interregnum period, which is 1/7/2021 to 4/5/2022, the court vacated the vacuum so beautifully with a very, very beautiful interpretation. It is completely the court's work. That's why I said this judgment has been written with so much passion and commitment to tax interpretation. The court filled it so beautifully. How did it fill it? It took two judgments, one from the Land Ceiling Act and another from the Income Tax Act, another tax law, a tax judgment, Chamundi Mopeds, and said, look here, till Ashish Agarwal was rendered on 4/5/2022, the whole case was in hiatus because its matters are pending. Ashish Agarwal gave the relief to the revenue in a particular way and extended the benefit to the assessee to participate in these proceedings to take it into a meaningful, meaningful end. Therefore, in terms of Chamundi, para 100 of the judgment is very vital. It says Ashish Agarwal did not quash any of these 90,000 notices. It did not quash it. Then you have a legs to stand to say your July 2022 or September 2022 notice is the starting point. It's barred by TOLA. It's not covered by TOLA. No, it saved those notices. It did not quash those notices. Having saved those notices, in terms of Chamundi Moped and in terms of VLF, the land selling matter, that's also a tax matter only. When an authority actually cannot do anything during that assessment period, that period should also be construed as a period of stay, is what Supreme Court has said even earlier. It's not saying for the first time. Two earlier judgments have said it is equivalent to stay of proceedings. And therefore, the proviso to 149, the new 149 will apply there and fill the gap. Now you read the judgment. 1/4/2021 to 36/2021 covered by TOLA. 1/7/2021 to 4/5/2022 covered by the inability of an AO to pass order in terms of Chamundi Moped and VLF. 4/5/2022 a program sheet has been given. AO has to follow that, and you have interdicted it. So, what is the time frame they have now given? 30 days to share the data by the AO to the SSC, 15 days to file the reply. If you take an extension, that will all add up. Then within thereafter 2 weeks to pass the order under 148 AD. And if they decide, take the sanction and issue 148 notice. It says one example. If a notice has been issued on 1st May 2022, I'll give you the paragraph reference itself. I'll give you the paragraph numbers.
The 112 gives that.
112, 112, 112. 1st May. Now, you are given 30 days from 4/5/2022 to share the documents. 2 weeks thereafter for filing the reply. 2 weeks thereafter for passing the order, subject to further extensions, if any. Exclude all these 60 days, 62 days. Then sanction should be, this time the sanction has to be obtained under the new law, not under the old law. Because 148A, B, all that has been now preserved under Ashish Agarwal, waived. But the sanction post 148D has to be done by the new authority. And that window period of 62 days, they are excluding all this. You get that balance 62 days will be the time frame available for issuing the 148 notice, is what the judgment says. It's very clear. It has not left anything to ambiguity. There's much more, a lot more to say, but so we'll have all good things have to come to an end somewhere. I'm ready to take a few questions, if any. But once again, I'm indebted to all my brothers and sisters who argued big learning, and all of us together as a tax community, trade, business, professionals, all of us should be very, very indebted and thankful to this court and to the author, the Honorable Chief Justice, for rendering a judgment of a unique sense. See, every aspect of it has been addressed. And based on foundational jurisprudence principle. Nothing has been left out. Mathematically put it, everything has been asked. Put a sheet, chart, tick box, everything will be able to tick it one way or the other. So we should be indebted to the court also for having rendered such a passionate and a beautiful judgment in, to say, in the Naniji style of writing. And therefore, there is so much. If you read the judgment, you will learn, you will understand what a judgment writing, a quality judgment writing can mean to a particular field of law. And this happens in constitutional law, this happens in social legislation, this happens in liberty legislation. You understand this is the velocity of a judgment, an impact it can create. And we are grateful, therefore, to everyone. And finally, to the trio, Arun and Sachin and Anjur, and to all the subscribers, all the revenue officers, and all the dignitaries, everyone, for this opportunity to talk to you. Pranams and namaste, and thank you so much, please.
Sachin, over to you, Sachin, for the questions now.
Thank you, Arun. I'm precisely, I think, at 75 minutes. I think Sir took it. Definitely, I think, sir, basis whatever you have suggested, everyone needs to, reread this judgment, to be very honest, because it's a process. And I completely agree with you. In the first reading, it's sometimes very difficult to, understand, comprehend so many aspects which have been dealt by the Honorable Court. I think, sir, with your permission, I'll go in the possibly the same order in which you have gone, to explain us the judgment. And the first, I think, the first 44 paras, I think you try to give us a sense of, what could be the interpretation. And I think succinctly pointed out the difference between a literal and a strict interpretation. Maybe for the benefit of everyone, and this is a question which is often coming in our minds, sir, that so many high courts, try to interpret this, and we have, equal, I think, respect to all the high courts as well, the way they interpret the law. Do you want to say, and I am trying to understand the way you try to explain the literal versus strict, whether the high courts then possibly resorted to the strict interpretation rather than the literal one? How would you, maybe, your guidance will help us to understand, how to read the High Court judgments also later on.
See, the area of vacuum is only twofold in intertwining TOLA and the Finance Act. That's one approach which the Supreme Court did not find favor with, because they only put simple question. Pre-amendment or post-amendment, both are only Income Tax Act. Income Tax Act is specified act under TOLA. It's such a simple. So this is one error in our very respectful view the High Court fell into. And the second one was, that is even more important, saying that it is therefore coterminous with 31/3/2021 and could not have extended to notifications. The wisdom of 3.1 was totally lost. And the third is this 151 sanction, and the way it has, with utmost respect, misread Ashish Agarwal. So the court was not very happy that the High Court has virtually sat on judgment on Ashish Agarwal in many senses. Even though there are 8 High Court judgments, see, in tax laws, this is a common phenomenon. When 1 or 2 High Courts first deliver a judgment, then it gets easily replicated into 8 or 10 by the other High Courts, because it's a central law, uniform law, and therefore, for example, in this FAFO, JFO, which is now the third round of litigation, one is Ashish Agarwal, second is Rajiv Bansal. Now the same set of assessees are now doing this JAO and FAO issue. You won't believe, I went to the Karnataka High Court, spent 4 days before the judge, a very learned judge, and I said, this is going to become a huge problem in the country, so please decide it. And a very competent senior counsel also argued on the other side, and we won. Revenue won. Nobody knew. Revenue won this case. Meanwhile, Surya Lakshmi was delivered by Telangana High Court, where many of these contentions, because somebody argued, not that. Whatever we argued was not argued there. So the assessee succeeded. This judgment was shown, and the Karnataka Division Bench stayed our judgment. Now see the replication and the ramifications. If you read the first judgment, which is also a High Court judgment under 226, so what would you do now? You will have to only, the Supreme Court has to resolve. Now to say that 8 High Courts therefore held it one way, it replicates, 7 High Courts have replicated one view of Telangana. Ultimately, if Telangana is wrong, rest of the 7 will also go wrong. Fair. This is how it happens in tax laws. You have to be
fair point, sir. Fair point. Because I think that is also one of the questions, participants have put it in the Q&A box, that, how this JAO versus FAO controversy will pan out. But I'll still stick to...
It's coming tomorrow, but it may not be heard tomorrow. We need to fix a date, and we have to resolve this JIFO and FAO. Enough. 2 things need to be resolved on a priority basis. One is this JAA FAO issue. Another is this 144C, this assessment. Okay, self drilling. Self drilling or shelf drilling. We have to see. These are 2 major issues which require resolution in the Supreme Court. Hope the court gives us some date and gets it done. Yeah.
Sure. Sir, I think you clarified explicitly as far as AY 1516 is concerned, maybe for the benefit of everyone. I'm just trying to repeat it. Whatever I understood, I think whenever we are looking at this particular judgment, since the judgment is starting with the issues noted by Honorable Supreme Court in para 18, which I think more concentrates on April to June 21, and then thereafter July to September 22. However, when we really look at AY 1516, and as you rightly pointed out, we need to look at 2 type of issues there. One, AY 1516 4 years, and the notice which is issued prior to 31st of March 2021. I think that is one set. We cannot, merge this set with the AY 1516 as a general. And secondly, AY 1516, where the notices have been issued after April 2021 to June 2021, and then subsequent things will follow. The second bucket, very specifically, when we really start with the para 19, where unfortunately it's a very generic kind of concede, position.
No, I'll clarify it straight away so that people are very clear. See, if you have issued the notice prior to 31/3, then your 4-year period will apply.
Yeah.
You will be governed by TOLA. You will be governed by TOLA.
Yes.
But all these notices are post 1/4.
Correct.
Whatever we are arguing. So for those notices, para 65, if you apply for 3-year, it won't enter the threshold of 20th March 2020. So it's gone.
Correct.
Straight away gone. No need for any discussion. You can be very, very clear. And if still orders are passed, the lawyers can make money by filing writ petition 226, show para 65 and get it knocked off. I hope they will not do it. I'll also request the board to, if possible, whatever needs to be done, we'll request that. But we should be very fair to ourselves. We have issued notices only under post 1/4. New law will apply. Threshold will apply. 15, 16, 4-year period, it won't. 6-year period, don't. 50 lakh, 6-year period, it will apply. Don't confuse that. So three answers. Initiated prior to 31/20/2021, old law 4 years will apply.
Fair.
Initiated between 1/4 and 36, 3-year will apply. This will get quashed. It will get barred by limitation. But 6-year, if it is extended beyond 50 lakhs, that is sustainable. You don't need TOLA at all for that. Simple.
Perfect, sir. I think broadly, this is the consensus. So just I'm extending this discussion to AY 1617 and 1718 for a better understanding. So for AY 1617 and 1718, the 3-year time limit, is coming into this Finance Act 2021 change scenario. And then the notices have been possibly issued in July to September 2022 post Ashish Agarwal. So what is the correct sanctioning authority here? Is it just because you are excluding the period?
That is what they have discussed in 3 paragraphs.
Yeah.
148A up to prior to 148 AD period. No, sanction has been waived.
Absolutely.
You can't invoke the new 151, even though notices were issued under that period.
Fair point.
Because I stood up and argued and got that point settled. So you can't undo it. But once when 148 AD order is passed and then 148 notice is issued, we understand from the revenue either orders are not passed at all. You have all come back again.
Okay.
Or immediately after 148D notice was served, before 148 notice was issued, you went and got a stay.
Okay.
This is the scenario. For people who have not gone, certainly sanction at the 148 stage under the new law has to follow new 151, not old 151. If they operated in the old 51, you have a right to quash. Simple. The protection under Ashish Agarwal is only prior to 148D stage, not post 148D stage, not at all. It's very clear.
Fair. So I think
ambiguity of that.
So we need to apply AY 1516 as you put it into 3 different buckets, and AY 1617 and 1718 also, we have to be very cautious about the sanctioning authority. So you also explained the surviving period, and there is some
sanctioning authority post 148 AD.
Correct.
We did that way because prior to 148 AD is covered by Rajiv Bansal. Completely dealt, comprehensively dealt.
Fair. Sir, on the on the surviving period, I have a couple of questions. I understand, the way this logic has been explained in para 107, 108, 111, and without the to be very honest, without the example given in 112, nobody could have imagined it, the way Supreme Court wanted. So I think we should thank Honorable Court to give that particular understanding by way of example.
There is finality for everyone. So
yeah. So I think, sir, just one aspect, the problem or the offshoot of this particular para, which is trying to explain this mechanism. The offshoot of this is actually coming in a way that there could be, just for the sake of discussion, sir, that if a notice is issued on 1st April 2021, and I'm just taking some example just to make my point clear.
Correct.
If the notice has been issued on 1st April 2021, or if the notice is issued on 1st May 2021, or if the notice is issued on 1st June 2021, and possibly the fourth example, the notice is issued on 30th of June 2021. Basis the example which is given in 112, all the subsequent impact are going to be different the moment the taxpayer submits the information either within the 2 weeks or as extended by the tax department. And then you are just going to add the surviving period, which is from the date of the notice. So if the notice has been issued on 1st April 2021, possibly you will include 90 days and 60 days, 30 days, and 0 day if it is issued on 30th of June 2021.
Correct.
So in a sense, sir, the point which I'm just trying to drive towards is we had two broader questions with the Supreme Court, and generally I think we understand that this judgment has been in favor of revenue, rightly so as far as the first question is concerned. But when it comes to the second question is concerned, and if I then try to read para 113, which is just before 114, which sums up everything, it unequivocally is trying to give you a clear idea that the notice has to be issued within time, basis 112 as an example, and with the correct sanctioning authority. So therefore, there is a possibility that for all the 90,000 notices, I'm just putting as a number, you will have to look at each and every notice when it was issued, compute the period, and then try to see whether it is within law or outside law. Is this understanding correct, sir?
Absolutely right. There's no doubt about it. There's no standard time limit. It is 121 for 112 formula may help assessee, may help revenue, whichever way it helps, that's the law. We are bound by that law. Let's not think let's not even speculate it is going to be in favor of revenue, it's going to be in favor of assessee. We don't have the data. Many have filed writ petitions and got stay. That we knew. And many notices have been dropped because of this threshold. And many notices will go for 15, 16. So if you eliminate all this, there is every possibility that having gone to the court, the revenue still may have time, having not got vacated. From the date of the judgment of you have to add one thing, I'm just telling the officers also, for those who have got a stay and all, add this time limit from the date of delivery of this judgment and then issue your 148 notice immediately. Take the sanction and issue, don't delay.
Yeah, exactly.
Yeah. Those who are enjoying stay or success in the judgment of the court, because this judgment now overturns all the judgments.
Correct.
So whoever has gone to the court, and requesting officers through this, and board can also possibly convey this very clearly, date of judgment of Supreme Court will be the starting point for the balance period. Take the sanction and issue the notice. Don't wait for anything.
Sir, but do you expect CBDT to come out with a similar kind of an instruction?
We don't know. We'll have to check.
Okay.
I can't speak for them. And they all work in unison. We are all one team. We have solid support we had in this matter from the ministry and from the board, and therefore we could do all this. So they may come. If it happens, we'll certainly will. If it comes to me, I'll certainly try to put my advice on that. Certainly.
So one additional question, very specifically again, I'm just taking one example, like we had a Bombay High Court judgment which stands overruled in JM Financial and Investment Consultancy, where the the AY 1516, 4 years, the notice was issued on 20th of March 2021, which initially Bombay High Court thought that it is time barred. However, it also agreed that it was a change of opinion. I'm just taking that one case for the purpose of discussion.
On merits, they have said, now once this is all disposed of, so once you have any other point, you can always initiate a fresh cause of action. If you're going to argue anything else, that is not, because 90,000 notices, how can we decide 90,000 opinions? It can't do anything else. So if there is anything else left out, you seek the remedy known to law. Those issues are not decided or covered by Rajiv Bansal. No problem.
So here there is a practical, possibly discussion which is happening, between the taxpayers is, this particular judgment only, gives this particular, the way the sanction should work.
Correct.
And in a case, and it set aside only the High Court judgment to that extent only. And therefore, in a case where High Court has also given a respite, one on the TOLA related point, and secondly on a change of opinion related point, you don't need to again go to the High Court because only the first portion is now set aside.
This was mentioned on that day. So a 3-line clarification has been issued. I don't have the copy of that.
Okay.
Please take that clarification also and go by that clarification. This was
Okay.
The court has passed a 3-line order on that. Go by that.
Okay, fine. I think that would be really helpful.
Go by that. It has issued some clarity on this very issue. Go by that.
Fine. Maybe, sir, last question, and then I could take a couple of questions from the participant if you agree. Sir, now this particular confusion has been, I would say, is there mainly between the TOLA, between the COVID, you already had a Finance Act 2021 coming in place. I think today we are discussing everything. We already have Finance Act 2024 has again made some amendment. Do you foresee any kind of a next round of litigation taking place? Sorry, but
No, I'll put it this way.
Uncertainty, sir. That's why.
No. Why should see as a law officer, as a revenue collector, we are very certain, we are very clear. Even after Ashish Agarwal, uncertainty is always assessee's prerogative, not our prerogative. So you went to court, and if you go to the court the third time, fourth time, well, we can't stop you from going. But asking me, this judgment has settled this issue on these notices, and I don't think a third round is possible.
Okay.
But our friends are our friends, so they can always, and clients' compulsions and their imagination, their professional efficiency, we don't know. We'll have to. Nobody can say what is in store for future, Bhaiya. Better not to fight, but if you fight, we will stand up again for the third round.
Oh my God. Okay, this is a precursor, sir. But sir, I think you did mention one important aspect, which is now in the current litigation, and there are number of questions on that. So let me paraphrase that and just put it one question to you. That there is a validity of a notice issued by JAO versus the FAO. How do you see, after resolving Ashish Agarwal, after resolving, Rajiv Bansal, we are again now stuck with this kind of a controversy. Where are we heading towards, sir?
You should ask assessees and their counsels. You can't ask us because we are fairly. See, I think if you read the first judgment of Justice Shamsundar of Karnataka High Court, which has never been shown in any other court, unfortunately, you read the judgment.
Okay.
Argued for 4 full days. Unfortunately, no. I went because to go out of Supreme Court for 4 days because the board anticipated this is going to land us in mess. So I went physically and did the matter in the larger interest of everybody. But then now judgment has lost its gone into the back burner, and you have generated so many things. In a respectful view, not correct. You read that judgment. All of you are professionals. You read Justice Shamsundar's judgment and all these judgment and see which is right line before Supreme Court decides. You decide it yourself and recommend that course of action to the assessee. That's all.
Fair point. I think definitely, there has to be some stock taking of the current situations here. Sir,
see, one advice, because you asked, our seniors used to say, and we have followed it, at least in our age groups of professionals. Give the advice based on law and not based on judgments. This is a fundamental way to advise a client. Now, the regime, the pattern of opinion making has changed. Competition, compulsion, there's nothing to mistake. So you now advise based on judgments and not based on law. Then you should be ready to risk this uncertainty.
Correct.
Our seniors used to say, read the law and see whether the judgment reflects that law. Otherwise, judgment is wrong. Law cannot be wrong unless it is declared unconstitutional. Judgment can always be reversed. This approach in advisory is very critical. Young professionals should understand this. But all of you are under terrific compulsions. You have to prove yourself to grow in the firm. You have to prove yourself to bring impress clients. You have to earn money. You have to have a bonus. There are so many things calculated. So we didn't have any of those compulsions in our life. So we read law. Therefore, I'm not mistaking you. But a good advisor is one who understands law and sees whether the judgment reflects the law correctly. Because judgment is human interpretation. It can go wrong. Any number. See, take MFN, take Rajiv Bansal, take charitable institutions, 10 high courts, 12 high courts, all have been reversed only. Ultimately by the Supreme Court after 7 years. This possibility is distinct. When you go with a judgment, advice based on judgments. Yeah.
I think fair point, sir. Sir, I think, I tried to paraphrase many of the questions here. And thank you very much for your wonderful exposition. Of course, I could not ask you all the questions, but I think suffice to say what we really expect now is to, there should not be a round three basis this judgment, and a smooth transition should take place. Either going, there are the wish list.
You have to put the question to my colleagues on the other side. They will have to decide, not me. We don't generate litigation.
So you'll have to pardon me a couple of questions. I can't not use my moderator's or editorial discretion here. I will. Sir, I've been now tracking Supreme Court almost on a daily basis for the past year or two. There are quite a lot of cases that are high-profile ones which are still pending. If I could categorize it into two buckets, one is a bucket which consists of substantive issues, say set satellite on profit attribution, say ESOP taxation, say Tiger Global, not Tiger Global, but say Mauritius tax treaty and so on.
Right.
And second bucket is a procedural, like we saw Rajiv Bansal, like we are seeing the DIN issue. Now we are seeing the JO versus on that faceless thing. So you have the second bucket. You think that the taxpayers currently are standing on a weak footing, the way Supreme Court judgments are coming from different benches. There was a perception, and I want to address that perception here, that there was a perception that a lot of the pro-revenue judgments were coming from a particular bench. Now you look at the last 1 year, they are coming from diverse benches. And the bench we were talking of has actually, they have demitted office. So now the question is, sir, that are the taxpayers on a weak footing vis-a-vis the second bucket of cases pertaining to procedural issues?
See, I'll put it this way, Arun. Weak or strong, ultimately, it also depends on how law gets appreciated by a particular court. That also plays a role. Even though we have to, a Supreme Court level, irrespective of the judgment bench, the law has to reflect the same view. Is ideal thought process, but may not necessarily happen. All right. So it depends. Ultimately, the individual discretion of a judge in understanding the law also plays significant, insignificant, minor, major, depends on the case. But one thing is very clear. I can say out of my experience, even when that article was written that a particular judge and a particular bench was allowing, we replied to that article. The revenue succeeded even those times before 11 different benches tax matters. Okay. It's not that one particular bench alone went in favor. So ultimately, it's a question of effort and question of how you work the case to the best of your ability, building a conviction. And two, the kind of support infrastructure you get from, as they get from the clients, as we get from all these team. It's a team effort. All, for example, in set satellite, the time we have spent so far in understanding the law, whenever we get an opportunity, we are going to argue our best. You will see it. It's not a covered case. It's not that Morgan Stanley, nothing of that sort. We want to re-argue, and we re-argued at length. There is so much of law in it, so much.
You're
And
already giving taxpayers sleepless nights
no,
now.
no, no. In fact, I should say, I know. See, when I should say this with admiration. Of course, Pramod Kumar fought with me in MFN on so many things, but the way he has ordered the judgment in the tribunal, which is now the satellite in the High Court in the Supreme Court. I don't mind mentioning it because he's a retired member. The way he has understood none of the subsequent judgment has ever factored it. Okay, so we have built a lot of literature on that because we have such officers in the system who are briefing us that way.
Yeah.
So it's a collective as so many. It's like stars, yeah. It's like
I
a cricket
understand.
match.
So can I be a little more direct? Are the assessees clinging on to these hyper technicalities? Be it we also saw in PayPal, in Roka bathroom. Are the assessees generally clinging on to hyper technicalities rather than fighting on substantive issues?
Yes.
Straight, sir.
Yes. Straight answer is yes. Yes. Unfortunately.
And then Arun, using this particular judgment for interpretation of machinery provision, I think could be, a lesson learned for all of us.
Yeah. In fact, when I was actually in the last week of before vacation with so much of pressure, Arun said you have to give a comment. I said only this in that comment. The second round was nothing but lawyers' effort, but they put the best foot, right or wrong. Our friends did not did not argue some unprepared submission. They gave their best, but something which they could have avoided. At hindsight, you may say you stand on the other side and say if you're an assessee, yeah, I know the compulsions. I've been an assessee counsel, so I'm not nothing to blame anybody. We all work under our own pressures and compulsions. Times have changed, but the bottom line, conventional thinking will prevail. Always give an advice based on law and never based on judgments. You will slip, you will err. Judgments will always get overturned. There is no certainty, but there is certainty in law. Even though it's a defective law or an incorrect law, till it gets cured, that's the fate of the law.
So if I'll end with this one. You said judgments get overturned, and it was fascinating to see you argue before Justice Nagaratna on a Mauritius tax treaty case. And Justice Nagaratna asked, "Is Westminster still alive? What about McDowell's? What about Azadi Bachao?" Fascinating interplay, sir, because once again, after 40 years of litigations, we are back to the question of form versus substance. What constitutes enough substance? What is only form? And so on and so forth. So I'm just wondering, sir, that as you say, judgments do get overturned. So who is to say that what was good law 20 years back will be a good law after 20 years as well? Because situations change, right, sir?
See, Azadi was laid down in 2004. You may not be able to get Azadi in 2024. And if such judgments get pronounced, they will need to be tested now. See, the investment pattern, the need of the country, the priorities at that point of time, you can't cling to the same law to say in 2024, India is still holding its own. We have our own strengths, we have our own equation ups. Now to demand, I'm bringing money, I want all laws to be scrapped. You can't apply, will not work. In fact, in one of the cases I faced, this is exactly what when the council could not answer in law. He came up and said, I am billing this many billion. Therefore, what? Therefore, we'll have to say Income Tax Act won't apply for you. Parliament has to take a call. How can you get it in an Article 226? You can't get it. The answer was, I bring so much. So you bring so much, no doubt, for which you go and ask for the concession with the Parliament and you get it done if you can do it. No problem. So these dynamics have to be calibrated properly. And judges are yet to get tuned. Some judges are highly tuned, some judges in remote high courts. You go and stand up before a fairly remote high court and say 1,200 crore demand, the judge will, for a minute, won't even, it takes time for him to come into alignment. So we as a law officer doing bandwidth of cases across territories, we see the pattern is in fact very erratic, to be very honest, because the perception is very erratic when it comes to When I say erratic, I mean it in the clinical sense, not finding fault.
Got it. Yeah.
And therefore, you should be very careful. Showing one remote judgment in your favor, saying that we have won and therefore this is the law, it can get overturned.
Beautiful, sir. Beautiful. Sachin, anything left from your side? Otherwise, we'll
No,
close this.
I just wanted to ask, sir, as a concluding question, sir, we are in a very short time, going to have a direct tax code, maybe a income tax act to 2025. I believe, we have a dispute resolution mechanism well built in that, so as to, reduce the dispute. I think that is what is, my wish list as far as the direct tax code 2025. Any views, sir, from you as far as, the way we have a Vivad Se Vishwas scheme, we have a e-dispute resolution schemes. How do you see, and also I must appreciate in the last 10 years, at least minimum, we do not have any laws which has been enacted, which has a prospective effect, in a sense, harmful to the taxpayer, at least to that, my understanding. So I think the government is working towards dispute resolution, definitely, and reduction also. Any particular your wish list, sir, from 2025 new direct tax code, which should, support this on a broader note?
See,
I know it's a policy kind of a question, but since you have so much of a depth of the disputes now taking place at various judicial forums, any word of wisdom from you, sir?
see, this much can be assured at the moment. Starting from the Honorable Minister, the Revenue Secretary, the board, and the people concerned with policy making, including the CA. See, the kind of effort people in the system are putting to give you the best. See, you should actually respect it. People, because we understand that we all need you and we are working for your good. And the kind of interface that is happening in terms of discussion, in terms of collection of data, in terms of collection of ideas in the last few years, there is a good connect between the trade and the system. So let me assure you the following. However, the law and the interpretation, see, diverse law, every law will have its own complexity. For example, in GST, I'll give you a comparison. We can follow that model also in income tax, is my view. Whenever an occasion comes, we'll ventilate it to the ministry. In GST, certainly the number of litigation has reduced. And three important issues where show cause notices have already been issued running to crores. Crores. When trade came up and pitched those issues, we facilitated, there was an interface, understood their problem, took it to the GST Council, resolved, and we have issued clarifications on three important issues. Pending show cause notices running to crores, automatically they will get dropped. So the mechanism henceforth is, don't come for an individual issue we won't be able to solve. If you can give us an idea, see, your finding fault is very easy because you can never make anything perfect. If you can share your inputs which will be of use, which will simplify, which will reduce litigation, we are ready to help you. And suppose the law is so faulty that the entire trade is affected because of that and spate of notices are issued. As we do in GST, we should also be ready in income tax to work out a solution. If we are wrong in our law, then we should issue clarification in spite of notices pending. See, the original thinking is once notice is issued, court should take care of it, judicial, quasi-judicial person should take care of it, administration should stay away. That culture has changed in GST. And the same system of heads are there for this also. So we will also work towards that objective in spite of direct tax code being good, bad, faulty, all that we don't know as the law works. But the resolution process, if it is an industry issue, we should capture it at the first instance, develop a solution, and irrespective of who is, now the reverse is also there. Suppose there is an industry problem. We say that this is what we have done for. You should also be prepared to pay the taxes here. Then you go to the writ court and start litigating for 10 years. You can't blame us. And say that you keep writing, law is bad, it's not correct. It should work both ways. As we are ready to solve your problems, if the problem resolution is against you because this is what the law is and you have advised wrongly, trade should also come forward and pay. Then dispute resolution is certainly bound to come down. If you start litigating every Mauritius transaction as the most valid and legitimate transaction, for 15 years you'll have to battle it out and take the risk. You may win, you may not win. It's a gamble. These are the issues. So it is not that law is bad. It's not that officers are all bad. I'm not trying to defend all of them. I've always said this. Any high-handed action of a revenue officer, bring it to our notice. We will deal it. We will support you there. See, nobody can take law into their hands merely because they have the power to administer. That's not a constitutional guarantee given to any officer in this country, in any law. High-handedness is one exception. We are dealing with a novel situation. It has to be two-way. We are ready to solve, and if the resolution is against you, you should also accept it. You don't want to accept it and you litigate, then why do you blame us? We are slowly reaching that stage. We want to give a helping hand in everything. See, take this case of MFN. Had you not fought, even now it's open. If you come, see, it's after all a policy resolution. It is still open for you to go and sit with the government and resolve. Will anyone stop you? You file a review, you file one more petition, you can keep litigating it. Then how will a policy maker interfere and find a solution for you? He'll say, okay, you keep litigating, you keep litigating. How will we solve it? You should also take a balance. If problems can be, after all, the policy maker is so open. They are no longer bureaucratic. They are very friendly. They are willing to listen. And if there is a solution possible, we will extend it. It's an assurance. So I have given you some indication also.
Very valuable, sir. Arun, what do you?
Sachin said he read the TOLA judgment several times over. I think we'll have to watch Venkat sir's webinar, this address several times over. There's a lot of hidden meaning, a lot of messages which need to be decoded. But on that note, we'll close this webinar. Venkat sir, I can't thank you enough, sir. I mean, thoroughly grateful for taking time out and answering those questions, with a straight bat. We already have so many messages saying thank you. And I do appreciate your candor. That be it a case which you won or lost, you're always there to talk about it, to answer the questions, never too gleeful about your victory, never too despondent in defeat. And I'm sure that many will carry that same attitude forward. Not every case can be Azadi. Not every case can be an MFN or Rajiv Bansal for revenue. So, you win some, you lose some. That's how the courts have been. But I'll close with one anecdote. And this is an anecdote I heard straight from one of our legends of the bar, Mr. K. Parasaran, former Attorney General. And this was the day after the Vodafone judgment of Supreme Court. I had taken a 1:30 flight, had landed in Pune at 3 o'clock after the court judgment back. And at morning 7 o'clock, I had to pick up Mr. Parasaran from a guest house and we had to go to a temple. And after that, when we were driving back to my house, and I was lucky enough to host him that morning, he told me about an anecdote. He told me about a Supreme Court case, a 5-judge bench, and 4 high courts were against him, or 9 high courts were against him and 2 in favor. It was about some categorization of rental income. And he opened, the bench opened by saying, all high courts except 2 are against you. And he said, those are the 2 that matter. He said that those 2 high courts are the ones that the chief and the other judge represent. So, and that's how he opened up the judges to an argument. I think that's the key. I've seen Venkat sir argue now for quite a few years, most of the time in favor of assessees, last 3.5 years for the revenue. I think it's also a lot about code craft. It's also about understanding the mind of the judges and making some concessions wherever required. A lot of people forget that in Vodafone, to win that case, Mr. Salve made quite a few concessions. I think Venkat's also made some important concessions during Rajiv Bansal, and I think court craft, we underestimate the significance of court craft. Right now, you're watching one of the best lawyers in our country at his peak. It's a pleasure to hear him in court. It's a pleasure to hear him on the Tax Sutra platform as well. Thank you so much, sir, for gracing that 75th TaxTonic. And thanks everyone for a patient audience. A lot of people, several hundred, have watched it live on YouTube. Sorry we couldn't take everyone on Zoom, but happy to have hosted this webinar and to have answered as many questions from Venkat sir as we could. Thank you once again, sir. Thanks, Sachin, for the wonderful moderation and spending 50 hours researching on this TaxTonic. I think that's the most you would have done for any of the 75.
Definitely. Thank you, Venkat sir.
Yeah, thanks to the
Thank you so
TaxTonic team as well, who put together this series
Absolutely.
week on week.
Absolutely.
Congratulations to everyone. Thanks for your patronage.